open the meeting. First order of business is a public hearing on, let's see, the one we're hearing is 2023-2343. Check and see if there's a sign-up sheet. Yep. Okay, everyone's got a copy of that amendment? I'm told that there may be another amendment coming in that's dealing with the same language, so this amendment will make language for that germane. Certainly what this does is to take House Bill 154, I think, and move it into this with a change. And so on the sign-up sheet, I have one name, but the author of the original bill is here. If she wants to speak, come on forward and just tell us who you are.
Thank you very much, Chairman Gray. I'm Representative Juliet Harvey-Bully, representing Tilton and Samberton, and I appreciate, just want to say I appreciate the efforts and of the committee of coming up with this language here, the amendment in House Bill 154. I think it does solve the problem in an original way. And so I'm just speaking in favor of the language and urging members to pass to amend Senate Bill 63 as amended. And
okay, thank you. Questions from senators? Seeing none, thank you very much. The only one on the list is Mr. Whitford.
Good morning, members of the committee.
Hit the button so that the light comes on.
Lights on. Okay. My name is Wayne Whitford. I'm president of the New Hampshire Health Officers Association. I'm here to address the committee and to discuss amendment to Senate Bill 63, which provides a revision in RSA 147-1, nuisances, toilets, drains, and so forth. The amendment to 63 adds the wording to 147.1, which states health officers may make regulations for the removal of nuisances and other items affecting the public health for conditions unique to the town in the adjustment and the health and safety of the people. Under RSA 147:1, health officers who determine that there is a need for local health regulation to address particular public health threats and present recommendations to the Select Board at a regular public meeting. Select Board discusses the need for regulations. It takes the input from the community at that meeting and votes on the proposal. We feel that the current process works very well, providing adequate public input, and that there is no need for revision. The New Hampshire Health Officers Association does have concerns that the wording for conditions unique to the town, being that unique is not defined, we foresee local nuisance regulations being challenged in the court on a basis of whether a particular nuisance is actually unique to an individual town. Any court challenge of regulation would not only be costly to the town with legal fees, but would delay the implementation of important public health regulations and tie up valuable times of select boards and town officials. Members of the board of the New Hampshire Health Officers Association represent health officers throughout the state, and are opposed to the wording in amendment to Senate Bill 63. We recommend the committee does not approve the amendment.
Thank you. Questions from senators? Senator Susie.
I may, and I believe you said it, I just wanted to be clear. You're speaking on behalf of the Association of Health Officers,
Yes,
not
ma'am.
just yourself. Okay, thank you.
I do have a few questions. The current language talks about removal of nuisances. Nuisances, as we go into the statute, as I know it, from being on the planning board, are things that are unique to that town, something that, attracts people or other things. So, working on that word nuisances and being, having something to do with the conditions, that's why, to clarify, we put in conditions unique to the town. How does that restrict things that you should have privy over?
Well, as I mentioned, unique is not defined here. We're concerned that there are a number of conditions that are nuisances that may be in many towns throughout the state. And if it's not just unique to this one particular town, we're concerned that that will interfere with the handling of that particular nuisance.
Using the current Webster's definition of unique, because that's what we would fall back on. If it is not unique and it does affect other communities, why isn't it something that we're handling from the Department of Health and Human Services?
And generally, 147:1 does address that it's being handled through the RSA.
And the reason this bill was written is because, in the opinion of some, the health officers have been exceeding what a reasonable person would say was their authority.
In general, the public hearings by the select board and open public hearing and notice within a community that anybody that has opposition to the particular regulation can speak, and if there is opposition within the community, can be denied.
Okay, that's all the questions I have. Anyone else? Nope. Thank you.
Thank you.
Anyone change their mind about wanting to speak? With that, we will close the public hearing, and we have the matter before us. I'm going to take, we got the new public hearing coming up, so that we can go into that afterward, but I do want to give Senator Perkins Coca a little time to get here. So I'm going to take a 5-minute recess for you to check on your amendment, and we'll be back at quarter after. I have a motion. Do I have a second? Second. All those in favor say aye. Aye. On, the only one I had the request on was the other one.
Okay. You have a vote, so.
Okay, well, I'll move amendment to 2343. Have a motion and a second. Ought to pass. The bill, the amendment is to replace all, so we'll move the bill. Ought to pass. And Senator Murphy seconds. We'll move the amendment 2343. Oh, all righty. So the current status is we have a motion on the bill, Senate Bill 63, ought to pass, and we have a motion to amend it with 2343. And we're now in voting mode. All those in favor say aye. Aye. All those opposed?
No.
We have a tie vote. And I believe that we'll go to the floor with the tie vote and talk about it there. But, and the amendment is to replace all. So I don't,
We should technically, I mean, Trish was right, we still have to take a vote on the underlying.
but the underlying one doesn't do me a lot of good when I haven't passed the amendment.
I understand that, Mr. Chairman, but as a matter of procedure, somebody could offer another, if that's voted 2-2, somebody could offer another amendment. Another motion, excuse me.
Then what I will do is we will take this bill and we will schedule another meeting of the committee. If that's what we need to do, that's what we'll need to do. Is that acceptable to everyone? Okay. The clerk will schedule a meeting. Motion come out of executive session. We have a motion and a second to come out of executive session. All those in favor say aye. Aye. All opposed? Okay, we're back and we're going to do the public hearing on 2337. To bring everyone up to speed, we did some proofreading on 2337 as it came out of OLS, and there actually is another amendment, 2380, which I think both are available in the back. The hearing was scheduled for 2337, so we will take that first, and after that public hearing, then we will talk about the amendment 2380. Is there? Thank you. And we only have one person signed up. Is there anyone else that wishes to speak on 2337? Deputy Secretary of State. No, that's fine. So we'll close the public hearing, and I have a highlighted copy of Amendment 2380, and so Uh, well, if everyone in the audience got both of them, if they want both? Okay. So the differences that I have between 2380 and 2337, page 2, lines 25, 26 and 27. There's just a very slight modification there. And what we were trying to do is to make sure that the towns knew that they could only select, the towns and cities, that they could only select one device, but they could select, they could determine how many of those devices they needed to accomplish the voting in their town. So this was a rewrite to make that clearer. Any questions on that? Seeing none, moving on to, and I'm using the new amendment 2380 for my page numbers, line numbers, so that I don't lose you. The next thing was on page 5, lines 30 and 31. In the original draft, they just called them voting screens, and we missed one, inserting the word privacy. So there on line 30, it says each voting privacy screen. So that was the amendment there. Page 6, line 28. There was an additional hand forward that needed to come out so that the wording now would say, shall be forwarded by the clerk to the Secretary of State. And then on line 32, we had a his without a his or her. So that was changed. On page 7, line 3, another his or her change. On line 14, we changed the way that appears there. It's still the same sentiment that was in the other, but we wanted to make sure that there was a separator between the two X's or the two numbers that will actually be in the other. So we added a semicolon, put the two sentences together. So it says vote for up to X. X will be elected. Insert the number of offices to be filled. And that also will appear on page 13, I believe. So, and that language should be, although not formatted exactly the same, it'd be consistent. Page 8. Page 8, lines 5 and 6. There are occasions when I'm in a town that has a voting machine that I can't insert the ballot into the voting machine. If the voting machine were jammed, if there was a problem, and I do not want the person putting ballots in the side bin of the voting machines that we have right now, the bins, because the reason you, in a non-voting machine town, the reason you hand them to the moderator is so that the moderator, by the feel of them, knows that there's just one ballot there, okay? And that's what they're supposed to check. So having someone have the ability to put them in the side pocket of the bins that we have now would take away that. So in here, put it into the counting device or follow the moderator's instruction for counting the ballot, gets them to that same place so that they wouldn't be using that side bin or other things that I can't even think of. So if there's a jam, the moderator may just put them in the side bin, but then take them right back out of the side bin to run them through the machine or whatever. So again, that maximum flexibility is what I was looking for in that. Page 9, Line 27, finds that the voter, okay, it took out the Eurocava in there. And the reason that that was is that there are now actually two methods that your ballot can be emailed to you. And that's the Eurocava voter to make sure it gets there in time. And then people with certain disabilities that are approved. And the Secretary of State had to remind me of all that. But we did take out that so that it, in either case, it says that the voter takes care of that. Any questions on that one? That one gets a little complicated. Next one is on page 10. We added or digital to that sentence because the two machines, whether you call it a digital image or actually print the ballots, right now, most of those machines, we envision that they will be looking at the digital images when they look at those. Page 11. Page 11, line 4. Again, we're trying to make sure that they get the right numbers on the sheets. So the return shall also include the number of all write-in votes, period, in the some do not include. All right, so again, just trying to make sure that they get the right thing in there. You've got the words in front of you if it wasn't clear. Basically what happened is that there was a period put after votes, do, in the some do not, was inserted into that, so. Okay, down at the bottom of that, we changed photocopies to photocopied with a D. And on page 12, lines 16, 17, again, just punctuation, taking out periods, putting in semicolons because it's an ongoing list. 13, at the top of the page, lines 5 through 8 are where the changes are. The original copy had on line 5, who shall have the same qualifications as those the commissioner who they're replacing, etc. Again, what we're trying to do is to make sure that they have the form as best we can. So certainly if there is someone there and they do have an alternate assigned by the same group, that's the alternate we want replacing them. But if then the rest was added, if a vacancy still exists, the chair of the commission may choose replacement from any other alternate attending the meeting. And again, I put the word may in there also because if for some reason, in his opinion, it would cause a problem, affect the quality of the board or another thing that he may or may not choose to appoint those. Lines 17, 18. Again, this goes back to that same thing that we talked about. I think it was page 7, just to getting that all together so that it is X and then a punctuation mark and then the X again. So it would read, vote for 9, 9 will be elected. And we wanted some kind of punctuation between the two numbers. And we changed the word filled to find. I think that's the place it was. If not, it's somewhere else. But yep. Okay. Down at the bottom page on line 30, we had mark in there, and it needed to be where to make the appropriate mark instead of mark the appropriate mark. So, and then on page 14, We changed it to hand count instead of hand counting. And
What one is that, Mr. Chairman?
that is line 11. Roman 2 in a hand count polling place instead of hand counting polling place. Okay. And again, the reason for this, and after this meeting, I intend to go over the House's election law committee is having a meeting on some other bills, and I did want to speak to the chair, vice chair, and anyone else who wants to listen about this amendment, so that they know that it's coming and what it says. So before we take any motion, is there any comments? Senator Spoken.
I did notice, I'm trying to get them this morning, but not having my swap. I did notice we swapped out the reference to the AccuVote title in at least one place. I didn't know if we just made sure we did that everywhere in here.
I believe that OLS did that.
Okay.
The Deputy Secretary of State, when your attorney was going through this, I believe that they searched for AccuVote. Always like to get our former colleague up here at the microphone.
Good morning, Erin Hennessy, Deputy Secretary of State. Yes, Jennifer Cote, one of the lawyers in our department, did LexisNexis searches for AccuVote. Surprisingly, there were not that many specific AccuVote references. However, the other language, like long tape and things like that, do refer to AccuVote. So we've also tried to address all of those as well.
Okay, thanks. I have a couple more questions. If I may.
Absolutely.
On page 7, line 26,
Are you using 2380?
I am using 2380, yes.
Okay, page 7, line 26, is that right?
Yes. It references persons who shall be permitted within the guardrail. And it says no person other than the Secretary of State and designees. I just wanted to make sure it was utterly clear that the designees needed to come from the Secretary of State's office and couldn't just be members of the public, for example. And so,
Well, there would be the Secretary's State and designees, and there, you want to put in the word there, designees, or you
or
want to?
designees of the office. Your language works too. I just want to make sure they're election officials.
You understand what she's asking for?
I do, Mr. Chair. The one thing to consider, especially with the Attorney General, is that sometimes they appoint, and the specific term is escaping my mind, but they're basically poll watchers for the day because something may have happened at a recent election, so that they're there to observe, to make sure that the processes that they're supposed to do are done. And those people are not necessarily employees of the Attorney General's office. They may have been former moderators that have done a good job, and the AG's office thinks that they would do a good job in that specific role.
If I may, Chair. Yes, and I'm aware that that may occur. In that in some cases, there are also poll watchers that are from both political parties, but I guess for this specific language, I wanted to make sure it was someone who had the relevant experience, I guess.
If I add the word there in front of designees in both 26 and 27, does that satisfy you? And still satisfy the Secretary of State? So it would read, Secretary of State and their designees, the Attorney General and their designees, the election officials, et cetera, et cetera.
I don't think it totally,
Okay, then you get to pick the next suggestion.
well, I wondered if, yeah, but I understand what Deputy Secretary Hennessy is saying, which is that if we said designees of the office, that it would not conform to practice, basically. Yeah.
And I just want to add the appointed poll watchers are actually not allowed within the guardrail. They
Okay.
are just outside the guardrail where they
Okay.
can see and listen.
Well, the reason for this
Shall
is
be
that
within the guardrail.
there is inspection requirements that are either handled by the Attorney General's office or the Secretary's office. And I guess in some cases, we've actually had both being at a polling place. All right, so that's what this is trying to get at, is those duties. And then the catch-all is down below where the election officer and, let's see, can authorize other people to be in there when there is a need. Okay. I didn't have any problem with the original language, but I'm not opposed to making it clearer. But
What if, and again, I'm not trying to micromanage, my intent here is just to make sure we're putting folks inside the guardrails that understand the procedures. And so what if we said qualified designees, which is intended to convey that they have relevant experience as designees?
well, if the Secretary of State and the Attorney
Designated them,
General
yes.
are the ones who are picking their designee, shame on them if they don't pick somebody that's qualified.
I agreed,
The
Chair.
statute doesn't prohibit them from appointing anyone.
And I totally agree, and I'm certainly not sitting here assuming that they would do anything else. I just think it does give a basis to challenge a designee that might be disruptive, or if some problem arose. And again, I'm not trying to imply that any problem will arise or they would pick unqualified designees. It's one of those long-term drafting questions. I just want to make sure we get right.
How about I take a different tack
Okay.
and I say representative of the Secretary of State and representatives of the Attorney General.
I like that.
Okay?
Does that work? Okay. Thank
There's
you,
no
Chair, for the
person-
conversation.
Other than representatives of the Secretary of State, and we take out and designees. The attorney representatives of the Attorney General, take out and designees.
Mr. Chair,
Yes, ma'am.
since you've opened it up to a committee amendment,
Absolutely.
on page 6.
Well, let me,
Okay.
since Senator Perkins Cook had the floor, I don't want to take the floor away from her because she did say she had several.
Yeah, I think just one more question, actually. So thank you for that conversation. That was great. Let me just get to the right page from my notes here. It's in 659-53. Okay, so on page 9 of 2380. Chair, you mentioned these exact lines, lines 27 and 28. Is this the only situation, and I know you know these laws better than I do, so I just want to make sure I'm understanding. Is this the only situation in which the moderator can bin the inner envelope outside of a formal pre-processing situation?
There is a provision somewhere that talks about opening the inner envelope to see if there is registration material in there. Exactly what that statute is, I'd have to go back and look at it. Again, since these are going to come in a non-standard envelope,
Yeah.
I don't know that we have an instruction out there that says they have to put it into two envelopes. Because if they have a number 10 envelope and they're trying to stick another number 10 envelope in there, it's pretty difficult unless you have a number 9 envelope or something else. And so, in fact, I was asked to be moderator again, with all my experience, but, this, it didn't, concern me a whole lot. I mean, I'm trying to do away with the outer envelope anyway, so that we can actually make sure that people have signed their affidavit, have signed it and printed it, or vice versa, make sure that their request and their actual attachment, are the same.
For an
But
opportunity.
as best I know, those are the cases. And anything else that we would do would disenfranchise somebody. And unless there's a reason to disenfranchise them, I try never to.
Right. I guess my only follow-up question then would be in that other RSA, which I can look up offline, are there protections about how to handle the voting material contained therein by the
I think it
moderator or clerk?
basically says to seal it back up
Seal it back up.
with tape or whatever.
Okay, I will take a look at that. And then just one more question, if I may, and I think this is a very straightforward one, I hope. And that would be on page 14. In lines 17 and following, we make reference to the electronic ballot counting device. I just want to make sure this is intended to be a reference to the e-poll books that we passed legislation about recently. And I suppose that question is directed at Deputy Secretary Hennessy.
Sorry, you said line 17?
Yeah, and following, it talks about polling places which use an electronic ballot counting device for the counting of ballots, so as opposed to the hand counting. And my understanding would be this is intended to be the e-poll books, but I'm just making sure I'm following.
We use the term electronic ballot counting device for any AccuVote type device. So
Got it,
any
okay.
device, that's,
Okay, so this is intended to include the new machines just
Yes,
approved by the
yeah.
PLC. Got it,
But not the poll books.
correct.
but not the poll books.
Right.
So those would be in a different section, probably
Yep.
about closing down the station. Okay. Thank
Because
you,
the
Chair.
sections that the poll books deal with are the checklist, check-in, check-out lists.
Yes. Okay. After the close of the polls would be a different part of the procedure.
Deputy,
Thank you very much.
Thank you. Page 6.
page 6.
Line 33. We have a his without a or her. My apologies for not noticing that earlier.
We have a what?
Page 6. Line 33.
Okay.
Catch.
That's all you got?
Yes.
Okay. Absolutely.
going back to page, and I'm using the newest version of the amendment, 2080.
Yep.
Going back to page 3. um, On line 28, the Secretary of State in the election procedure manual published pursuant to 65222. There's, when I was looking at 65222, there really isn't much guidance as to what needs to be included, and then, the zipper probably doesn't need to be included in here, part of the prescriptive language that's being removed, but I'm wondering if it should take out the memory device or the county device housing all
believe-
parts.
I believe that both of the machines that we approved, or the ballot law commission approved, have memory devices that can be sealed. That, oh, if that's the case, does that lay your comment, or?
Well,
One, as I believe, has like a thumb drive. And I'm not sure whether the other one has an SD card or whatever. But they would both, I think, meet the definition that we're here. Deputy, you have comments?
Thank you. I think the intention to do it this way was that each of the, as long as the 2 devices that have been conditionally approved are fully approved and have gone through all the steps that they need to take, we'll have 3 different devices in use in our, say, state primary election in September. And each of those devices have different ports and places to seal. So instead of specifically pointing out for each device in law where to seal them. But to your point, yes, they have memory cards that are within the, closed within the machine, and then the machine would be sealed closed. As opposed to, I believe the AccuVote just has a sticker over where the card goes into. So each of them is a little bit different on where the seals would be placed.
While you're thinking, this isn't standard procedure, but it is up to the chair. Is there anyone else in the audience that's shown up here to listen that has any comments? Let me know. All right, we've got 1 thumbs up, and no one else is running up here to speak. So again, I want to make sure that we get everyone that is showing up that wants to tell us anything. Okay.
I'm fine with that, Evan. Thank you, Mr. Chair.
Okay. All right, so I have a motion on the original bill of, I'll move on to pass. And we have a second. I will move the committee amendment, which is based on 2380. Does anyone want those changes read back to them by the secretary or the aide?
Yeah, I think just for clarity, we're good. I think there are only 2.
That's for her. It's for her. Page 7, line 26, because we no person other than representatives of the Secretary of State, representatives of the Attorney General, then the election officers, the voters admitted.
Okay. With that, we'll take the amendment. All those in favor of the committee amendment, say aye. Aye.
Aye.
All those opposed, nay. Ayes have it, and now the bill is amended. All those in favor say aye. Aye. All those opposed, nay. The ayes have it, and I will take this one now. Anything else for executive session? Okay, and we will schedule that next meeting. We'll try to do it again on Tuesday, which is our normal day. But-
Motion to come out of executive session.
We have a motion to come out of executive session. All those, do I have a second? I'll second it. All those in favor say aye. Aye. And our business of the day being complete, we are adjourned.
Hey, good morning.